This is Laws 11057. This is the final week before the exam week, and we're talking tonight primarily about the examination. So we have a number of students online, so welcome all of you. And I welcome any questions that you might have as we go, and please interrupt me at any stage. But as indicated, primarily I want to talk about the examination. I understand the exam is Friday week, but correct me if I'm wrong in that regard. And I understand that each of you will make your arrangements for the location of the examination, and the exam will be one where you're writing in longhand. So that will be a challenge for many of you that are used to typing. Sorry. Now, what I propose to do is just talk in terms of the exam generally. You may have noticed on week 12 that there is some material which has been inserted. There is on week 12, and I'll just go to it now. Firstly, some extract of my notes, which are mostly based on material from LexisNexis. There is the RAIQ contract, which is there for legal study purposes only, and I remind you that you're not to use that for commercial purposes. It's inserted on the website for study purposes only. And there is the Introduction to Law Standard Exam, which was used in Term 2 last year, and I'll be referring to that. The exam in Term 3, which is mine, will be in two parts. If you want to get an idea of what it's going to look like, simply look at Term 2, and it's almost identical. There is one exception, and that is that in Part B, which is worth 40 marks, students are asked to answer all 4 questions, which are of equal value. So I'm afraid that there are no choices. You need to answer the 4 questions that are there. It is in 2 parts. The first part is multiple choice. The task is relatively easy, although complicated by the fact that some of the questions are quite long, and as you might expect, that there are subtle differences between some of the answers which are provided for you to consider and choose from. The second part is more in terms of essay-style responses, and the sort of responses that you would normally see in assignments. So, does anyone have any questions about the structure of the exam, how it might look?
Not so much on how it might look, John, but how the multiple choice section would be marked. Because when I was a student back in the 60s, they tried a system whereby multiple choice, 5 questions, 5 possible answers, all could be right, all could be wrong, or any combination of those. And you got a mark for a correct answer, but you lost a mark for an incorrect answer. And what they did, they decided to try and set a pass rate rather than the pass mark. And they decided that 40% would pass. And to do that, it turned out that the mark was -7.
Oh.
So someone who didn't actually write a thing would have passed, which made a nonsense of it, so they dropped it.
Yes. No, look, in this instance, certainly I wrote the exam, so it may be that I'm open to criticism that there is more than one correct answer, in which case my response would be that in my view this is the best of the answers, even though you might argue that others were correct as well. And it's simply a tick if you get it right, and no tick if you get it wrong. And the right and wrong is, I'm afraid, arbitrarily determined by me. So so you don't go backwards. If you get an incorrect answer, you just don't get a mark.
So, John, when did you
Yes, Jackie?
first realise that you didn't like us? When did you first realise that you didn't like us very much?
No, it's fine. I'm sure you'll all do very well. I'm sure you'll all do fine. All right.
We have to be mind readers.
Yes,
Is
Carla?
that it? We have to read your mind.
No,
We have to read your mind.
you'll be fine. All right. So any questions on the multiple choice or the structure? As I said, in part B, there are 4 questions and you need to answer or attempt to answer all 4 of them, each worth 10 marks. Okay. Preparation, content of the exam. The first thing yes, Carla?
Part B is the essay question. Will they be like a case with that we have to apply the IRAC method, or will they be like questions of a certain topic that we've from the chapters in the book?
It could be both, and I don't think it's about a specific case, but I won't say that it can't be. But no, I don't think it'll be a specific case, if that assists.
Yeah. So we could have cases. That's what I meant. We could have. It's not only an essay a problem. It could be a problem question and not an essay question.
Yes, it could be both.
Apply the IRAC method.
It could be. Yep, absolutely. Thank you.
Okay.
All right.
John,
Yes, Jackie. What's that? Sorry.
There's not going to be any referencing, is there, in the essay sort of writing? Do we have to do any referencing? Because if we do, how are we going to?
Look, I think you could attempt to do some referencing,
Okay.
and you might attempt to do some referencing in the body of the answer in the paragraph, or you could do a footnote or an end note if you wish. But I could understand that becomes a bit difficult when you're doing it handwritten style.
Yeah. Okay.
One suggestion might be to, I'm not sure, have a separate piece of paper for the reference section if you choose to reference. But you certainly won't be marked down if you choose to reference in the body of the material, even if it's a bracket, for example, you know, reciting a case. So don't worry about the normal sort of setting out. Because it's handwritten, we'll be very flexible.
Thanks.
Right.
Thank you.
No, that's fine. Now, any other questions about the structure of the examination?
Will we have draft papers given to us?
Yes, Carla. In week 12 of Moodle, you'll see the exam paper from last term, which was prepared by Wayne Jones. I have followed the same format, except that in that paper last term, you'll see that there were 5 questions, choose 4 of the 5, whereas in mine, there are 4 questions in part B I'm talking about, and answer each of the 4.
Okay.
I think it's also possible. I've seen through the questions and answers on the Moodle site a reference to how you can go about obtaining previous past examinations if you want to. But I don't think you need to go far back. I think just have a look at the one from last term. It'll give you a really good idea of what to expect in the exam. All right. Now, in general terms, I'd like to talk about the content of the material which could be contained in the examination. The first one, I'll start with Read the New Lawyer. You've probably picked up during the term that I'm a real fan of this book. I think it's beautifully written and logically written. So I would certainly invite you to go with that book and read it. You'll see that even there I've tabbed a lot of material. I expect that you probably do the same thing. You're entitled to take in that book to the examination. So if you only had room to take one thing, that's what I would suggest you take. Read through that, have it highlighted. You can make notes on the side of the page. You'll see that I've highlighted there and I've written down little notes to myself. I've got tags with notes up there, different colours. You can do all of that. There's no constraints at all in that regard. So it's not like back in my day where people used to walk in with things up their sleeve and written on the back of their hand. You don't need to worry about all those sorts of things. So number 1, read The New Lawyer. Not that I did that. I'm not saying I did that. Number 2 is...
Not judging. Yeah.
No, thank you. Number two, I would suggest that you consider Indigenous Australians and the law, and consider the concept of terra nullius and the Mabo decision. Now, I'm not giving very much away there, I know that, because I'm sure you would all have considered that that's a big possibility for the examination. So, terra nullius, the Mabo decision. Now, on a different topic entirely, I would suggest that you think about a concept that I've tried to follow through throughout the term, and that is this concept of thinking about being a lawyer now, thinking about what it would be like to be in your first year of a law as a law graduate. And that's in a formal context, whether you're in an office being asked to do something, or in a courtroom being asked to do something, or even in a social context. I've talked to you about, okay, if you're a lawyer, you're in a social context, how do you address people? How do you address a judge? How do you address the Attorney General? Those sorts of things as well are all examinable. So concepts about being a lawyer in your first year and finding yourself in situations where a lawyer may find him or herself, I think are important, and I've tried to emphasise that during the term. So that's the third thing. The fourth thing on my little list of things that you can't see is legal research skills. Obviously, the material that Kelly Steniford provided us with early on in term has hopefully been of good information, or provided you with good information. That's examinable, but it may be more useful in the sense of helping you to provide information. So you can print material from Austlii, you can print legislation, you can bring all that in with you if you want, but you can't access the internet while you're in the examination. So number 4 is legal research skills. Number 5, in terms of content, I've got court systems, federal and state and tribunals. There's no surprises there. How the court systems work, what type of courts primarily deal with what type of matters. Nothing too detailed, but I'll certainly touch on that, or invite you to consider studying that. Number 6 is similar, and that's court process. You'll recall we had one Zoom session, or maybe a couple of Zoom sessions, where I've said, within the context of criminal law, okay, how do you prepare for court? What do you do to make sure that when you stand in front of a magistrate for the first time, you understand what you're doing? So it's one thing to say, well, you prepare properly, but what does preparing actually mean? And then, once you appear before a magistrate, what does appearing actually mean? What do you say? How do you go about your business? So something to do with the court process, and I guess it's fair to say that, given that a lot of my background is to do with criminal law, that there may be an emphasis on criminal law in that regard from a practical perspective. Again, all part of this thinking of, well, I'm a lawyer, what do I do? So that's number 6. Number 7 is the sources of law. Again, I'm not giving much away here, I'm afraid. You'd all appreciate that it's likely there'd be some questions or some questioning about how we get our law, where it's derived. Legislation and common law, obviously, are the 2 main areas. So something about how legislation coexists with the common law and what the common law is all about. Common law, of course, is judge-made law. And also, and maybe Mabo is probably the best example of this that I can think of, judicial activism. We've talked about that during term, and you may well find that there'll be some questions about that, tying in the sources of law with the concept of the Mabo decision and the way in which judicial activism has assisted in making some new law there. So that's number 7, the sources of law. Number 8 is really dealing with common law, and it is the doctrine of precedent. So just have you won't need a detailed knowledge of this, but just a basic knowledge of how precedent law works. The doctrine of precedent, what are the general rules that apply? When can a court make a precedent? When is a precedent binding? In which courts and which tribunals is a precedent binding as opposed to persuasive only? So that's number 8. Number 9 is talking about the common law in the context of black letter law versus common law in the context of equity. So that dichotomy between the law and equity that we talked about. The black letter law being where law is strictly construed as per the letter of the law, so to speak, as opposed to this concept of equity. And we talked about the history of equity, how it was established in the early days, and how that coexists. So some basic knowledge, you don't need a lot of knowledge, but some basic knowledge about what we mean by, for example, an equitable principle or an equitable remedy. For example, specific performance is an equitable remedy that we talked about in the context of the REIQ contract. It's a remedy where you can force the sale to proceed, as was originally the subject of the contract, in terms of the contract, as opposed to a common law remedy, say, of damages. So equity is all about fairness, and we talked about how that can coexist in terms of principles or remedies that are available. So number 9, black letter law or common law versus equity. There's no particular order to these. These are just things that I thought of on the run, preparing for tonight. Number 10, I'd written down separation of powers, and keen for you to understand the separation of powers in our Westminster system. Obviously we have Parliament, we have the executive, and we have the judiciary. And what that means in practice. Now, coming back to judicial activism, there may be the argument that in the High Court decision of Mabo, essentially the High Court was making new law. And does that breach the separation of powers? On the other hand, when the Parliament makes mandatory sentences, does that impinge on the separation of powers by cutting into the power which is given to the judiciary, for example? And then maybe we talk about the executive power and delegated legislation, where the executive have power to make laws or to make legislation. And does that impinge on separation of powers? So just talk about, have a basic understanding of separation of powers, and perhaps some concept of where the edges are blurred, and where there are arguments about those blurring, offending the separation of powers rules. So that's number 10. Number 11 is constitutional law introduction. We've talked briefly about Section 51 of the Constitution, the powers which have been conferred upon the Commonwealth Parliament as a result of that section of the Constitution, the powers that the Commonwealth Parliament has to make laws in relation to those areas which are referred to in Section 51. The basic principle that the Constitution of the Commonwealth, the powers which have been conferred upon the Commonwealth override the powers conferred upon the states by virtue of the Constitution. So just some basic introduction to constitutional law. You don't need to know a lot, but you'll need to know some of the basics, and that's number 11 on my list. Now, again, I'm sorry that there's no particular order to these things. Number 12 is completely different. Number 12 is alternate dispute resolution. We've talked about different ways that a lawyer might resolve an issue. And in my view, alternate dispute resolution, which is mediation or conferencing, or perhaps arbitration, are different ways that matters can be resolved, different to litigation through a court dispute, as it were. It might be that mediation, for example, is on the way through. And during the Zoom sessions, we've talked about how mediation is effective. We've talked about what are some of the special rules that apply in mediation sessions, some of the advantages and disadvantages. So I'd like to think that you have some basic idea of what mediation is all about, how it works, what are some of the basic rules and principles. We've talked about what a mediator might say at the outset of a mediation by saying, look, in this mediation session it's confidential, can't be raised in later court proceedings, etc. So some basic rules about alternate dispute resolution. In that regard, can I also remind you that we had a session about advising a client in your first week in a law firm as to different ways that you can resolve an issue. In other words, have you thinking more broadly than, here is the law, we must go to court and we must sue. There's many other ways, many other techniques that lawyers use in practice. And I'm very keen for you to start thinking about how to use those methods, those different concepts right now, and put yourself in the situation of being in a law firm, for example, next week, and being asked to give a client advice in relation to a problem. So you need to understand different ways to resolve the issue and different ways that you might advise a client in that regard. So number 12 is alternate dispute resolution and alternate ways to resolve a dispute for a client. That's number 12. Now, number 13 is criminal trial procedure. During the Zoom sessions, we talked about what's involved in a trial in brief, and the process of the Crown, the police, having to prove beyond reasonable doubt that a defendant is guilty of the charge, and having to call evidence, calling that evidence in examination in chief, where the prosecutor will call the witnesses and the prosecutor will ask the witness to provide that evidence. In circumstances where the prosecutor can't lead the witness, but can really ask an open-ended question only. And that's a rule when the witness is presenting evidence in examination in chief, as we say. So just to explain that in a bit more detail, a person is charged, let's say, with trespass. The matter is contested, the matter goes before a magistrate's court. The police prosecutor will stand up and announce to the magistrate that he or she will call the owner of the premises, Mrs. Bloggs, as the first witness. Now the prosecutor will stand up and will be allowed to lead that witness with some leading questions at the start. Things like, your name is Mary Bloggs, you live at this address, you are the owner of this property, you were the owner at that on a certain date, and there'll be no objection from defence to that. But after that, the examiner, the police prosecutor, needs to ask open-ended questions and not leading questions. Now, how can you tell if something's an open-ended question or a leading question? The general rule is if the answer can be yes or no, then the question is probably a leading question. So if, for example, I was to ask a person in the witness box a question like this, so the car was red, the answer is yes or no, that's a leading question, as opposed to an open-ended question, what colour was the car? So hopefully you can see the difference. So the rule is that in an examination in chief, you must ask open-ended questions, but in cross-examination, which is where the defence gets up, the defence is able to ask leading questions, and that's usually what happens. So we'll talk about, we've talked about this during the course, and I hope that you have some basic idea of criminal trial procedure. We've also talked about bail applications and some of the issues that might be relevant in that area of practice. So that's number 13, criminal trial procedure. Number 14 is criminal law again, client's rights. We've talked briefly about the right to remain silent, the right to proceed to trial, and the right to sit back and ask the prosecution to prove their case beyond reasonable doubt. There is no obligation, for example, on a person charged with an offence to give evidence at the trial. They simply can remain mute, and the magistrate, or in the magistrate's court, or the jury in the district or Supreme Court can make no adverse inference as a result of the fact that the defendant chose not to give evidence. So some basic idea of clients' rights in criminal law proceedings. That's number 14. Number 15 is coming back to the new lawyer, the areas of law, categorising the areas of law: criminal law, administrative law, contract law, family law, constitutional law, torts law, whatever it might be, but just having a basic understanding of these different areas of practice, and having some idea of what these areas of practice mean in reality. So that's number 15. Number 16, and I'm getting close to the end now, is we talked about contract law by way of an introduction to contract law. And without needing in any way a detailed knowledge of contract law, we did talk about what's involved in the formation of a contract. This was through Zoom. Offer, acceptance, communication of the acceptance, intention to enter into legal relations, and consideration. We contrasted the difference between an offer and an invitation to treat. An invitation to treat being a situation where someone is inviting a person to make an offer, but in itself it is not an offer. And the example that we used was something which is advertised for sale in a shop would generally be regarded as simply an invitation to treat rather than the offer made by the shopkeeper. All of that, of course, is subject to consumer law, and in particular the consumer provisions. But in pure contract law, there is that clear distinction between an invitation to treat and an offer. So we talked about that briefly as well. Nothing in any great detail, but just to give you an idea. We also talked about, in contract law, the RAIQ contract and some of the rules that are important for you to know. We did that in the context of you being in a law firm and being asked to provide advice to a buyer or a seller. I've highlighted some of the issues associated with the RAIQ contract. Don't go into too much detail. It's really just to give you a taste. You don't need to study that in any great detail. Now, the next one is number 17, theories of law, coming back to the new lawyer, natural law, legal positivism, etc. So have an idea of the theories of law and what they mean as they've been described in the textbook. It's number 17. Number 18, this won't be a surprise at all. legal problem-solving techniques. I particularly like the CIRAC or CIRAC method, but that's not the only one. There are different techniques. There's no right or wrong answer as to which one to use, but just have an idea and have that available for you. Have it worked out in your own mind which one technique you like to use, and you'll probably be called upon to use it, to apply it, particularly in Part B of the examination. So just have an idea of the legal problem-solving techniques. Number 19 is wills and estates. We had a brief introduction to wills and estates. Wills, of course, being documents that are signed now with the intention of being effective upon death, but having no legal force until you die. A power of attorney being a separate document, not in the same document, but a separate document, giving someone power to make decisions and sign documents on your behalf while you are alive, perhaps incapacitated. And a power of attorney may become effective, if you choose to make it effective, if you lose capacity. And we talked about capacity in the context of QCAT and guardianship applications. Capacity essentially meaning that someone is not capable of understanding the nature and effect of decisions, communicating that decision in some meaningful way, and understanding the nature and effect of the consequences of that decision. So we talked about wills and estates just in an introduction, nothing too technical. Now the last two issues that I've got written down, number 20, effective legal writing. Again, I've sort of tried to emphasise that the approach used in modern legal practice is to use an economy of words where possible, try to write in a clear style, try to keep the sentences relatively short, try to make them readable for a person at a lower rather than higher reading ability level where possible. So those long, complicated sentences need to be rewritten in an effective legal writing style. So just be aware that that might be on the paper as well. And number 21, ethical duties of lawyers. We've talked pretty much throughout the course about legal ethics in various contexts, and you need to have some basic understanding of that. Now that's all that I've got written down for the content. I may have missed some areas. I apologise if I have. I've certainly not covered in that list of 21 things all the material in this book. That's not to say that what I've indicated in those 21 is not going to be in the exam. There may be material in here that I just haven't covered on, or material in the course which I haven't included in that brief summary. So my apologies. And just because I've mentioned it as one of the 21 doesn't mean that it's part of the exam. Sorry to do that to you.
Yeah, you look sorry.
Yeah, sorry. Now, before I go on to the logistics, which was my third and final area for tonight, are there any questions that any of you have about the content of the exam, or any questions about what I've said during that, giving that list of 21?
Are we allowed to write the essay questions with a pencil, or are we? Yeah, that's my question.
Yeah, no, you may have to write some essay questions, Carla. What was that, sorry?
No, I know it's a silly question, but are we allowed to write the essay question with a pencil, or do we have to write with a pen?
I don't have a problem. If something's presented in pencil, I won't have a problem with it.
Okay.
That's fine.
Just
It'll be coming to me.
With
So
the footnoting and everything, I thought it might be useful that we can erase and.
Sure. If you want to go with a pencil, then that's fine. I don't think there's any. I haven't seen of any prohibition. Okay. Please, if anyone has seen something to the contrary, please let me know. I would suggest probably a pen, though, to be honest. Yeah. All right. Thanks, Carla. Any other questions about the content? No one? All right. Logistics. Now, this is covered in the material. I think I've sent you a link to some material that you can access if you wish about the examination process. But in short, just to confirm, you can take in any written material. Now, that includes the textbooks, legislation, secondary sources, your own notes if you wish. I think that you should follow the recommendation which was noted by Wayne Jones, that you produce an exam book, something that you can refer to quickly once you determine what you want to put in your answer. So some sort of skeleton or guide. So some sort of exam book. Next, when I said you can take in any written material, that is to the exclusion of an ordinary dictionary. You can't take that in, but you can take in a legal dictionary. What you can't do, of course, is have access to the internet. So you can't take in any electronic devices, especially one that can connect to the internet. The exams are written in longhand. If you have a problem with writing in longhand, then you'll need to make an application for an application to be considered for typing your exam instead. I'm told, however, that there have been no such applications, and in any event, it's rare that they're approved. And all the exams, of course, are held on the same day in different locations, and I understand that you can check on your own CQU account to find out where you'll be sitting your examinations. So please let me know if there's any problems in that regard. All right. Well, that completes everything I'd prepared for tonight in terms of the examination guide. I hope that's been of some assistance. Before I stop recording,
Good. Thanks,
are there
John.
any questions? Yes.
This is Destiny. I just have a
Yes,
question
Destiny.
about the notes that you can take in. You said that we can take in written notes.
Yes.
What about notes that you've typed up yourself, so you've made it all up alphabetical and so
Sure.
it's easier to look through? Is that okay if it's typed up?
Absolutely. That's fine.
Great.
Yep, that's fine, Destiny. That's fine. Thank you. Anyone else?
You're going to love my handwriting.
Oh, thank you, John. I'm looking forward to that. And remember, you don't have to write a lot necessarily. It's the quality rather than necessarily the quantity. So, does that help you, John?
Try and help you.
Okay, thank you. All right. Any other questions? I won't go round the room. Oh. All right. Well, look, if you have any specific questions, please send me an email. And what I might do is stop the recording now. And all the best.
Thanks.